Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
need.
Running a little late because we got backed up this morning, so we'll do our best to be tight this afternoon. We're here on the arraignment portion of the docket. Mr. Gates, you want to do some of your out of custody, or
yes,
I can do some that don't have lawyers?
I can do my 3 real quick out of custody, and then we can go to unrepresented. I'll make it
Very
easy.
good.
Your Honor, first I'm going to call Dustin Ford. Should be number 27 on the docket.
Okay.
Last name? Ford. At this time, Your Honor, we're going to enter a not
This
guilty.
is 23 CF 2141. Sorry. Go
Yes,
ahead.
Your Honor. Mr. Ford is before the court in 23 CF 2141. At this time, will enter a not guilty plea. In his case, he's currently scheduled for December the 11th.
Very good. We'll enter not guilty and continue until 12/11 at 9 a.m.
Thank you, Your Honor. Okay. Your Honor, next I've got is going to be Derek Jones. Mr. Jones should be number 34 on the docket.
Okay.
He's before the court in 23 CF 2292. At this time, we're going to enter a not guilty plea, and he's currently scheduled for December the 11th.
Very good. We'll enter a not guilty plea, and we'll continue this until December 11th at 9 a.m.
All right. Okay. Your Honor, last I've got is going to be Tyler Kendrick, number 36 on the docket.
Okay.
He's before the court in 23 CF 2168. At this time, we're going to enter a not guilty plea. He's currently scheduled for December the 11th.
Very good. We'll enter a not guilty plea, and we'll continue this until December 11th at 9 a.m.
Okay. Thank you, Your Honor.
Okay. So there are several folks that are here in the gallery that I presume are here on the arraignment docket. And I'll call your name up that don't have an attorney. The purpose of an arraignment docket is merely to make a plea. Occasionally, the state will make an offer to resolve your case, but primarily we're here to make a plea of guilty or not guilty or no contest. If you do not have an attorney, when obviously you don't, if I'm calling you up unrepresented, you do have a right. It's important to understand you do have a right to have an attorney. If If you cannot afford one will be provided to you. So I'll do that, and if I do appoint an attorney, what I'm going to do is enter a not guilty plea in your behalf so that you can preserve your legal rights, and then meet with your attorney and then come back, and we'll give you a date in December to come back. So, Mr. Nopes, you want to do yours real quick? Are you ready to go on your arraignment? You've only got one, I think.
Well, he has an arraignment, but I also scheduled him for a bond hearing today.
Okay.
You might want to do the bond hearing after the arraignment, please.
You know, we've got so many, we're going to be backed up. Bond hearings don't take that long. You're not going to be calling witnesses. Who's your, let's see who your
It's
client is.
Chris Ballew, B-A-L-L-E-W.
Okay. Is it in there?
You put Chris Ballew in there with them. You put number 46 in also. Here you go, Mr. Nopes, this is his information.
Okay, I'm on Blue, Christopher Blue, correct?
Right.
I've got 23 CF 2029.
Judge, he's got, I noticed 2 cases for bond hearing today. He's got the one you just stated,
Right?
which is on the arraignment docket. I think I already filed a written plea of not guilty. That's your stuff. And then he also has 23 CF 2001. That case is possession of controlled substance and possession of paraphernalia. When he went to first appearance on that case, the bond was set at $3,500 cash.
Hold on.
We did got set for 130, but I didn't know it.
That's all right. That's all right. Don't worry. Go ahead.
So he had a possession of controlled substance, which was set $3,500 cash or professional at first appearance. The paraphernalia was set at $1,000 signature. He's asking the court in that case to modify the bond in count 1 to make it a signature bond. And then the one that's on for arraignment today that I also noticed to modify the bond, count 1 is $3,500, count 2 is $1,000. Those are both cash or professional bonds, and he's asking the court to consider making them signature bonds. He can't afford to make any bonds. And he's been in jail quite some time.
State?
Your Honor, so the state's understanding of what occurred is that the 23 CF 2001 case, which is 1 count of possession of a controlled substance, and then 1 count of a possession of paraphernalia, it looks like that occurred on September the 4th. And then on September the 6th, he gets a new case. And the new Grand Theft Auto case, and his bond is revoked at first appearance.
But it's not. It was a mistake. If you look at the notes, the judge, first appearance said to rescind that order.
Sorry, Judge, I'm just looking that up. I don't see where. I guess on the 11th. Okay, Your Honor, I'm sorry. It does look like Judge Selector did come back a couple of days later and rescinded the order revoking bond. But in any event, Your Honor, the state would oppose him getting a bond. He's got 2 charges that occurred within just a couple of days of each other. And the state doesn't have any certainty that if he's out on bond that he won't be committing new crimes, and the state
What's
has.
his prior criminal record, and what are the FTA's prior record?
Yes, Your Honor.
What
Give me
record
just
of FTAs does he have, if any?
Just a second.
Judge, I can tell you that I looked at his charges in the past, and believe it or not, I don't know if it was a mistake or what, but I think the first case that had his name attached to it years ago, there's a failure to appear in the clerk's docket, but that's been years ago.
And that was actually a court mistake. I was actually incarcerated and couldn't make it.
So,
Well, Your Honor, the state doesn't have any failures to appear listed on his score sheet, but I do have a battery on a law enforcement officer, a fleeing and eluding, a prior felony battery, 4 prior possessions of a controlled substance, 2 prior sale, manufacture, delivery charges, and 12 prior misdemeanor charges.
Judge, that doesn't change our problem is we're broke and we don't have the money to make the bond.
I'll lower all the bonds to $1,000 cash or professional each one. You got 4 times $1,000 cash or professional. Based upon the history, I'm not going to bring it to a signature.
Your Honor, is that with pretrial services?
What pretrial services are you requesting?
Level A, Your Honor.
Which is? I don't have that in front of me.
I have a first appearance sheet here somewhere.
Judge, count 2 in 23 CF 2001 had already been set at a signature bond. So is the court going to change that, or we're just going to?
No, I'm not going to change that.
Okay, so that'd be $3,000 total.
Correct.
Your Honor, weekly reporting, and it says standard pretrial service conditions, and I'm looking to see if I can find what the standard conditions are. I'm just looking at first appearance paperwork for that. Would request a substance abuse evaluation and treatment, Your Honor.
You might be better off just to stay in jail.
I'll sign for probation if they'll take it.
Still plead probation. So, okay.
I'll have the weekly check-in, that's all the pretrial services at
Yes, sir.
this point.
Okay.
Okay?
All right. Thank you, Judge.
Very good. Thank you.
And as for today, one of the cases is set for plea day, the other is not.
Mr. Nope said that he filed a written not guilty plea, that's why I didn't.
I don't have it in yet, but I'll just check for it.
Okay, and if it's not, he's entering a not guilty plea.
Yes, sir.
You can put that in the court records if it hasn't been in. Okay, thank you.
Yeah, and the other case is scheduled, it was in the other division, and they flipped it over here, and it's set for 12/13.
Okay. So this one will come back on 12/13 as well.
Very good. Thank you, Judge.
Okay, thank you. I agree. I agree that somebody's got to not put it on this. Somebody put it on, and that didn't come through our office. He can put it on, the lawyer can just put it on? Don't the clerk say you can't do that? I don't know. I've not heard of a lawyer being able to just put it on wherever they want it. Okay. I'm going to call out some names for folks that I've got listed as not having an attorney. If you'll come forward to the podium, we'll announce your case and you can make a plea, and if you wish to have an attorney, you can have an attorney appointed. Begin with Esteban David Alonso. With the state announce.
Yes, Your Honor.
We've got a lot of cases. The faster we can move, the faster we
I'm sorry,
can
I'm
get
looking
through
through
this.
Looking through the docket, Your Honor. Your Honor, this is 23 CF 2279. He's charged with driving while license suspended, habitual traffic offender. The state does have an offer for him to plead to a misdemeanor DWLSR third or subsequent for credit for time served if he would like to take that today.
Do you wish to talk? You have a right to have an attorney appointed. I can appoint you an attorney. This offer will stay on the table. You can communicate with your attorney unless you want to try and resolve it today.
I'll try to resolve it today. I'll take the offer.
Okay? So we're going to pass over this, put it in writing, and we'll get it going from there. So just hang around and we'll get it done.
Yes, sir.
Okay? Timothy Blankenship. State, please announce.
Yes, sir, this is 23 CF 2351. Mr. Blankenship is charged with 2 possession of a controlled substance, 1 possession of nitrous oxide, and then 1 possession of paraphernalia. The state's offer involves community control and 3 years of probation, or 3 years of drug offender probation.
So, Mr. Blankenship, do you wish to have an attorney appointed? You have a right to have an attorney appointed.
Yes, Your Honor. I've filled out the paperwork here.
Okay.
But I do have something for the court records, and that's my prescription for the 2 Xanax.
Give that to your
All right.
attorney. So I'm going to appoint the public defender and enter a not guilty plea on your behalf. We'll come back on December 11th at 9 o'clock.
Yes, sir.
Okay?
Thank you.
Get. Thank you.
Put the application in the clerk's office.
Justin Brown.
Just give it to me.
State.
Okay.
Your Honor, this is 23 CF 2207. The state's offer involves probation in this case.
So, Mr. Brown, you do have a right to have an attorney appointed. Do you wish to have an attorney appointed?
Yes, sir.
Court will appoint the public defender. Court's going to enter a not guilty plea in your behalf so you don't give up any of your rights, and we'll continue this till the 11th of January at 9 a.m. You'll meet up with your attorney in the interim and see where things are going, okay?
Yes, sir.
Thank you.
Thank you.
December
What did I say?
11th.
November? That's December 11th.
It's around December 11th.
December 11th, that was my mistake. Okay, Thomas Brundage. State.
Yes, Your Honor, this is 23 CF 2202. And Your Honor, the state did have an offer for Mr. Brundage, but the victim called while I was in court this morning, and I do need to call her back before I make any offers.
So, Mr. Brundage, you do have a right to have an attorney appointed. As I stated, you wish to have an attorney appointed, or you're going to hire private counsel?
Yes, sir.
Appoint the public defender?
Yes, sir.
Court will appoint the public defender. I'm going to enter a not guilty plea in your behalf. You can come back on December 11th at 9 a.m.
Yes, sir.
Okay, meet up with your attorney in the interim, okay?
Yes, sir. Thank you.
Right here.
Collado, Justin Collado.
Fill out that application.
State, please announce.
Yes, Your Honor, this is 23 CF 2198. Your Honor, the state is prepared to make a probation offer to Mr. Collado today, but I haven't spoken to him about that, and I don't know if that's something he's willing to accept without speaking to an attorney.
I'd like to speak to an attorney, or attorney appointed, please.
So you wish to have an attorney appointed?
Yes, please, Your Honor.
To appoint the public defender, you still need to fill out the application, okay, and turn it in today before you leave. But the court's going to enter a not guilty plea in your behalf. We'll come back on December 11th at 9 a.m.
Thank you, Your Honor.
Thank you. Tyrese Davis. Is it cold out there?
It's the rain. It's just a cool rain.
You look like you were bundled up.
I just got back from a conference in Pittsburgh, so maybe it's just.
You have to talk with your new compadre next to you. She's used to the cold weather up in New York.
This thin blood.
That's why she
is
moved
not.
south.
I am more lizard than that.
Your Honor, Tyrese Davis is 23 CF 2273. I don't see Mr. Davis approaching the podium, and I do note that he is out of custody.
Was he given notice?
Beg your pardon, Tyrese Davis, Miss Dudley filed a
Written not guilty?
today.
Okay, thank you.
Okay,
She must
very
have done
good.
that.
Thank you.
Thank you, Madam
And
Clerk.
so we're going to go ahead and set it. Did we set it on 12/11? Yes. Okay. Perfect. Thank you.
Your Honor, I have a couple of out of custody.
Okay, let's,
He's finishing the note.
go ahead. Yeah, you can if you want.
I'm sorry to interrupt.
That's all right. No. We're doing you can do out of custody. I'll do it. I've got some that don't have attorneys.
Thank you, Your Honor. Could I call Christopher J. Dixon, and then it'll be Spencer A. Efat? Your Honor, Christopher J. Dixon is approaching. His case is, I'm not sure which, docket number 23, I think, 23 CF 2224. At this time, he will enter.
Hold on a second. I've got this Christopher Germain.
Christopher J. Dixon, right?
J. Dixon, okay. Now, I've got it as no attorney, so you've been appointed already?
To my knowledge, I have a file. I think I'm appointed, at least provisionally. If he has not filed a public defender application, he'll need to turn one in.
Okay.
He says he's done that, Your Honor. So I would like to enter a not guilty plea and keep him on the December 11 docket.
Very good. Court will enter the not guilty plea and come back December 11th at 9 a.m.
I'm sorry, Judge.
No, I just was announcing the next date, December 11th. Not guilty.
Thank you, Your Honor. Mr. Spencer Efat. Mr. Efat is approaching in docket 25, I believe. 23 CF 2145, Spencer Armand Efat. Did I pronounce?
You did.
Okay, man. Your Honor, Mr. Efat would like to plead not guilty and remain on the December 11 docket.
Very good. The court will enter a not guilty plea and we'll continue this till December 11th at 9 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Any other cases, Mr. Medina?
No, Your Honor, those are my two out of custody. I have,
So we'll
other inmates.
continue with some of the out of custody without attorneys. Mr. Stephen Fickert, if I pronounce that, did I pronounce that right?
Yes, sir. Judge, this is case number 23 CF 2246. Mr. Ficker is charged with battery by juvenile on health services personnel. Your Honor, there is no offer at this time. I'm attempting to contact the victim.
Okay. So at this point, you do have a right, Mr. Fickert, to have an attorney. You wish to have an attorney appointed?
Yes, please.
Okay. Court will appoint the public defender. Court will enter not guilty to protect your rights.
Thank you, sir.
We'll come back on 12/11 at 9 a.m. for the pretrial. Make sure and get up with your attorney before then.
Okay, thank you, sir.
James Graham. James Graham.
Judge, this is case number 23 CF 2136 and 23 CF 2137. I do not see Mr. Graham in the courtroom.
Was he properly served?
Let me check.
I almost did. We'll do those. What's the first one?
Christopher Godwin.
What, which one?
Godwin.
Godwin. Okay, we'll do that.
To the left.
Okay.
He is represented in a different thing by Mr.
Okay. Let me,
Yes,
we
Your
gotta
Honor.
finish with the other case. Just hang tight.
On
Counselor?
On Mr. Graham's case with the last digit 2136, it looks like he was served. Notice was created and sent to the bondsman on September 22nd. And it had the correct date.
Okay, very good.
I would request a KPS.
Court will enter a KPS without bond. Okay. So let's do.
Christopher Godwin.
Yes, Your Honor. Travis Gates on behalf of Mr. Godwin. I actually am appointed in his VOP. That's 23 CF 682. That's scheduled for arraignment next Tuesday at 9 a.m. However, after speaking with the state and Mr. Godwin, I was able to resolve both cases. So the court will have me appointed to the case for arraignment this afternoon. We do have a plea agreement to be filed.
The court will appoint the public defender. Do you already have the plea agreement?
Yes, Your Honor. I just need to get Mr. Godwin to sign it.
Very good.
And Judge, while he signs it, the plea agreement, my understanding is it was for 9 months. And that was a prior offer extended to take care of both. It was going to expire today, but I'm honoring it. It's not a downward departure. He scores 38.6 months, or 38.6 points.
14.
Thank you.
Yes, Your Honor. And
what are the two cases? I know you've got 23 CF 2175. What's the other case number?
23 CF 682. And that is correct, Your Honor. Mr. Godwin was in court last month on the VOP arraignment, and at that point, there was some confusion, but Mr. Losco had offered him 9 months on that. And then there was this case outstanding we had to try to get worked in as well.
Very good.
I appreciate Mr. Losco honoring that offer.
Mr. Godwin, step up to the left.
Give the score sheet.
No.
I'll send it.
Mayor, Your Honor.
You may.
The state will be sending score sheet later, Your Honor.
Very good. Would you please announce the terms of the agreement, counsel?
Yes, Your Honor. Mr. Godwin will be admitting the violation before the court in 23 CF 682 and pleading no contest as charged in 23 CF 2175. He'll be adjudicated guilty in all counts and cases. In 23 CF 682, we're going to revoke and terminate his outstanding probation, sentence to 9 months in the county jail concurrent with credit for all time served, $100 cost of prosecution, $150 public defender fee. Mr. Godwin's asked for 24 months from the date of release to pay those outstanding fees. In 23 CF 2175, 9 months in the county jail between both counts, concurrent with credit for all time served. That is concurrent between all counts and all cases. $615 court costs, $100 public defender fee. Mr. Godwin's entering a plea without the opportunity to review discovery as well as the FDLA reports in this case. And again, if he could have 24 months to pay those outstanding fees.
State.
That's correct.
Mr. Godwin, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Mr. Godwin, you heard your attorney state the terms of the plea agreement. I see those same terms are contained in the written plea agreement, and which you have signed. Have you read this closely?
Yes, Your Honor.
You went over it in detail with your attorney?
Yes, Your Honor.
Okay. You had all your legal questions answered? You understand that by entering into this, you're waiving the right to go to a trial and some other legal rights in order to have a final resolution of this case. Is that what you want to do here today?
Yes, Your
You
Honor.
believe that's in your best interest?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt on all counts and cases. In 23 CF 682, the court will revoke and terminate probation and sentence you to 9 months in the county jail for each count. They will be concurrent with credit for time served. You've got cost of prosecution, public defender fee. You've got 24 months after you're released to pay for it before it goes to collections. In the other case, 23 CF 2175, pretty much the exact same sentence, 9 months in the county jail. That will be concurrent with the other charges, both within the new case and with the other case. And the same fees and costs, and you've got 24 months to pay those as well. And you are entering this plea without the opportunity for discovery. You went over that with your attorney and what that means?
Yes, Your Honor.
Okay, do you have any questions?
No, sir.
Okay, thank you very much.
This one, Mr. Godwin, I'm going to get you.
Thank you.
Chad. Great, Chad, great.
Mr. Gray, if you'll come up to the podium. Oh, this is Mr. Gates. Thought it was unrepresented. Go ahead. Would you announce
Your
the
Honor,
case?
technically, the case before the court is unrepresented. However, I had this other case, 23 CF 430,
Right.
travel along with this case so that I could get appointed to the new case as well.
So I assume you want Mr. Gates on that new case as well appointed?
Yes, sir.
Okay. So what are we doing for today? We just entering a plea or?
Yes, Your Honor. I talked with the state. I was pressing to try and get an approval or at least an answer for mental health court. They have screened him, they've approved him. The issue is the case before the court today is considered a VFO charge, a violent felony offense charge. I've already talked to the victim, who's his mother. She does want him in treatment and to get help, so my inclination is to think that that's something we can get done. Would the court allow me to set him for the 27th of this month and see if we can't get an answer from the state, at least by mental health court, whether it's an option or not? That's the date the court set next week's arraignments for the following Monday.
Sure. Yeah.
That way I don't have to put Mr. Gray in December, and if we can get it resolved, we can get it done sooner than later.
November 7th at 9.
27th at 9.
27th.
All right.
Okay.
Do you want to take the December 11th date as well, or no?
Yeah, let's
We're
keep
gonna
it.
see. I'll push him for that.
Just add
Yeah.
9 a.m.?
Yes, ma'am.
Ashley Green will be next. Yeah, wasn't Green?
Would the state announce on this is unrepresented?
Yes, Your Honor. This is.
Well, hold on a second. Wait for the defendant.
Mr. Medina, did you, after you done with that, did you want to do the 3 from this morning?
That'd be wonderful, sir.
Thank you. The screen to the lectern. To the lectern, straight ahead. On the podium. Yep. Podium screen.
Would the state announce the case?
Yes, Your Honor. This is Ashley Green, case number 23 CF 2323. She's charged with criminal mischief over $1,000. If she'd like to resolve this case today, Judge.
Listen up, ma'am. Listen to what he's saying. That's important.
If she would like to resolve this case today, Judge, we would resolve it with a withhold, 24 months of probation, court cost. She'd have to pay $406.59 to the victim in this case. And 24 hours of community service, anger management, credit for time served. So she would get out of that.
Okay. Are you interested in that?
Yes, I am.
Or you do have a right to have, before you say that, let me just say to you, you do have a right to have an attorney appointed. If you'd like to talk with your attorney to make sure it's a good deal or whatever, I can appoint. We can probably still all wrap it up today.
We can still what?
We could still finalize it today if you have an attorney appointed. I just want to, if you want to have to talk with an attorney about their plea offer or about anything, I just want to make sure you get that opportunity. Or you can just go along and they'll put together the plea agreement. If you're
I would
good
like-
with it, if you're comfortable and you feel like you've got enough information,
I would like to do the plea agreement, because I do know I need anger management, and I have the money to pay what they're asking for already and whatnot. I can do probation for 20, how many months?
2 years, 24 months.
Okay. If anything, I'll call my attorney, because, well, he's not here, and Michael McGrail was supposed to show up. He never did.
Okay.
I'm sorry, Judge, I think I might have misheard her. Did she say she has an attorney currently and we didn't show up?
I think she said, she had spoken with one, but he's not.
He's my
not
personal
made an
attorney.
appearance. And so, if he hasn't made an appearance, you're not in an obligation to talk to him, I don't think. So if she wants to go along with the plea, I'm okay with it.
Okay, Judge, can we pass her so I can draft it?
Okay, so what we need to do, we're gonna just hang with us. We need to put it in writing so we can get it all squared away. We'll get it done today, okay?
All right, that's fine, Ms. Gray.
Do I need
And Ms.
next?
Gray needs to go to the end of the line, so she's gonna take a plea.
I don't think so.
I didn't know. Better afternoon.
You want a blank one, or you want a type one?
Don't we have something?
Yeah, but I think it's brief.
Those are the 27th and 29th.
Yes, sir.
Please and sentence.
When I look at your stuff, I just see stuff. I can put these on for 9 o'clock on 27. I just don't want to do it.
No, I agree. We need to- You want me to just want to take a break? Well, remind me when I run out the door.
Come on.
Thank you.
Did I give you my card?
Which one are we doing?
I think we're still doing unrepresented out of custody.
Okay, you want to go back to that? Hold on a second.
Making appointments. Walk out the door, making appointments. We may be done with all.
I think we're done with the.
We're done with all the
We have a
unrepresented.
brief this morning for Mr. Medina, please.
Okay.
Your Honor, I do want to address one issue. I have a Gilbert Enclave on the document.
I'm sorry, say that again.
It is Gilbert Goncalves. It's 23 CF 2247. We scheduled an interpreter. I met with him yesterday. Turns out he speaks Portuguese. So we were able to make the interview work. There is a probation offer for him that he was interested in taking. I just don't know how, we don't have an interpreter right now. So I don't know how the court wants to handle that. It's kind of a food for thought because it is a probation offer. It would get him out of jail today.
I mean, we do have language.
And as long as the court's comfortable with that, I did go over the terms with him yesterday, so he knows what's expected. There's obviously states he's here legally, but I did put in the plea agreement it would subject him to deportation out of abundance of caution.
I don't know where different courtrooms, so. I don't know where our language.
We don't have to take it now, Your Honor, just letting the court know we'll need language line at some point with him.
Okay. I don't know that we're going to be any better prepared later in the day. Pretrial services generally, but they're not, they wouldn't come up. Usually we do it in our first appearance.
I know, I've seen it done here first. I don't know that they can get their offices in the month. I mean, they do come here, but it's not for long.
Why don't I just, when I have to take a break, I'll check into it. So it's two things. Two things I have to do it right.
I have Mr. Askew for
Okay.
Mr. Medina.
Mr. Askew's, Daniel J. Askew is returning before the court from the morning docket. I'm not sure what number he was on the docket, but his case number is 19 CF 3282. And we have an agreement. There was one slight change. I need to make sure the state understands it and he understands it. May I have just a moment?
You may.
Because it's a 19 CF case, non-community control, so he's going to be on a unit. So it'll be a concurrent 1 year on the third-degree felony. So
He had some time, because he had some
yeah,
time.
because he already had some time here, and I didn't want to make it an illegal sentence.
Okay.
It's still 3 years.
Okay, so.
And I'm just pulling out the score sheet, making sure Mr. Askew is aware of that score sheet. And this is a reinstate modify, so it's not technically a, I don't know if we need the score sheet. Got a little ahead of myself, Judge. May I approach with the agreement, Your Honor?
You may.
Ready to sign? All right, man. May I, Your Honor?
You may. Thank you.
Thank you. Your Honor, under the terms of this violation of probation agreement, which has been signed by all parties, we're going to be resolving not only 19 CF 3282, but also 23 CT 1195. And that originally pled out this summer in a global deal. So it's always been part of the same supervision. And it's going to be dealt with in this agreement as well if the court accepts it. Defendant will be admitting the violation. He was previously adjudicated guilty as charged in both cases. It'll be reinstate, and it's a little bit complicated. You can't be on community control at Keaton, so it's going to be a new term of 3 years probation so it'll be reinstate and modify supervision to include a new term of 3 years probation on count 2 of 19 CF 3282. Count 2 is a second-degree felony with 15 years, so there's plenty of supervision on that. With a special condition of bars to bed Keaton, and except as to the new term on count 2, and then I put an asterisk, there will also be a new term of 1 year concurrent probation on count 1. That's a third-degree felony, so on a 19 CF case, I didn't want it to be an illegal sentence, so it's just a 1 year concurrent probation on count 1. Just as a technicality to make sure we're not running in excess of 5 years on count 1. So, except as to the new term on count 2 and the new term of 1 year concurrent probation on count 1, and the Keaton substituting for substance abuse evaluation treatment, he will have to complete the original requirements in 19 CF 3282, whatever they were. There will be a revoke and terminate supervision in the 23 CT 1195, but he'll still have to do the obligations, which will transfer to 19 CF 3282. $100 VOP fee in 19 CF 3282. $50 VOP fee in 23 CT 1195. And $200 total public defender fees, Your Honor.
State?
That's the state's agreement, Your Honor.
Mr. Askew, let me swear you in and ask you a few questions.
Sir.
You swear or affirm? You swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Did you hear your attorney state the terms of your plea agreement?
Yes, sir.
Did you understand it?
It's a lot.
Because You're a better man than I am if you understood it all, because I was having a hard time following. But it's important, it's more important for you to understand it than me.
Yes,
I mean,
sir.
I understand it
Okay,
generally.
so-
But I want to make sure that you don't have all your questions answered. I want to make sure, all kidding aside, you need to understand this. I don't want you to go back and something happen and you be sitting somewhere and go, well, I didn't really understand that. And then something happened, you go, well, I didn't realize that was it. That's not what
With the
we're not trying to trick
community
you.
control, Like, it's just gonna be.
You're not on
it's-
community
it's
control
done.
anymore.
Yes, sir. Okay,
Okay.
yes, okay.
But this is a new 3-year terms of probation.
Yes, sir.
Okay, are the other terms of probation, I didn't follow what you were saying.
Okay, Your Honor.
Kind of just,
there's
kind
a
of break
new-
it down to me in English. You got 3
Yes,
years,
there's a new 3-year term of probation.
and Keaton's gonna be a part of that.
And Keaton it's bars to bed Keaton.
Right.
He has to do Keaton, no question about it. But because count 1 in the the CF case was a 3rd-degree felony.
Right.
I didn't want him to exceed the 5 years supervision, because it's a 19 CF case. If we added 3 years to a 19 CF case, it might go over 5 years of supervision. So therefore, to deal with that, it's just a concurrent new 1 year on count 1 felony VOP. So it's concurrent. It doesn't matter to the practical world, because he'll still be doing 3 years 3 years probation with bars to bed Keaton.
So if he gets out early in Keaton, he's still on probation,
Yes. And
right? Do you understand that?
If I get out early?
If you get, when you finish, you're gonna,
Yeah.
hopefully you're gonna successfully complete
sir.
your Keaton program.
Yes, sir.
What is it? Is it a year, 18?
No, it's a 6-month program.
6 months.
It's
Six
6
months. So when
months
you-
in, and then there's 6 months aftercare typically.
Okay, so when you get finished with that program.
I have 2
say
years
you-
left.
You still got 2 years.
Okay, yeah.
Well,
Yes,
I just wanna
yes,
make
sir.
sure you understand.
Yes, sir.
It's not exactly, may I just,
Yeah,
I hate
tell
to
me
be
straight.
particular, but we don't know when he'll be going to a bed at Keaton. As soon as it becomes available, he'll go, but your probation starts running today. So if it were a little while before you got to Keaton, your time is still counting on your probation beginning today.
Yeah, I mean, sometimes the beds aren't available, it might be a couple weeks
Yes, sir.
to get into Keaton. So, but you're getting time for that.
Yes, sir.
In other words, either you're serving it on the front end before you go to Keaton, or on the back end after you get out of Keaton.
Yes, sir.
You're still doing a total of 3 years. And within that 3 years, you're gonna be doing a program at Keaton.
Yes, sir.
That's the core of this, plus, of course, all the money, they always have to get in your pocket for some money. And, so, the VOPs and the different costs that are contained that were outlined in there, so. With that understanding, you do understand this is the final resolution of your case, you're giving up the right to go to a trial, do you understand all that?
Yes, sir.
You've had all your legal questions answered
Yes, sir.
with your attorney, you feel like you understand what your plea agreement is.
Yes, sir.
Okay, any questions?
None.
Mr. Medina, do you have a
Just,
question?
I wanted to beat a dead horse a little bit,
No, you
because
can't. Go ahead and beat it.
the CT case wasn't just in any kind of a case, it was a DUI case. So the DUI requirements are among the existing obligations that are transferred and still hanging over your head, that's still gonna be part of your probation, will be part of the CF felony probation. You still gotta comply with whatever outstanding obligations you have on your DUI charge.
Okay.
You following with that? You understand what he's saying?
Yes.
Okay. When you get out of Keaton, first thing you're gonna do is go to the probation office, right?
Yes, sir.
Sit down with them and talk to them and say, hey, what do I gotta do? Make sure I'm clear about it. Again, the whole purpose is saying, we don't wanna have anybody get in any trouble because they didn't quite understand something. We want you to understand it. Of course, then you gotta do the hard part, you actually gotta do it.
Yes, sir.
But we want to be straight with you and give you a fair shot at it, so you can be successful,
Yes, sir.
okay? We got enough people in jail, got a full jail over there, right? You don't need anybody else. We'd rather have you stay out here
Yes, sir.
in the community. I'm sure your family would like that too.
Yeah, very much so.
Okay, very good. Thank you very much. Good luck.
Okay, thank you.
Take care, man.
Sir, you do have 30 days to appeal this ruling, this.
Yeah,
sentence.
he's already been printed, yeah.
Thank you.
Thank you. We probably need Rhonda DeWitt. Your Honor, Steve Medina with Rhonda M. DeWitt, and Ms. DeWitt is recalled from this morning, docket 4623 CF 688. I've spoken with her in the state. We would like to bring her back on December 14th for a VOP, not evidentiary.
Very good. We'll come back, continue until 12/14, December 14th, at 9 a.m.
Thank you, Your Honor.
Yeah. That's not right.
Your Honor, Steve Medina with Elizabeth A. Dills, docket 4723 CF 2313, and we have an agreement that resolves this case, and I've been over it with Ms. Dills, and she's ready to sign. The prosecutor's already signed. The state attorney's already signed.
Thank you, Your Honor. Thank you.
Thank you, ma'am.
Thank you, State.
Appreciate it. Thank you. I need to pull out the score sheet, Your Honor, if I may.
You want me to?
So here.
We can talk when I bring in your paper, when you're paid.
Well, just,
That's the first I've ever seen this. Cool. Appreciate it.
may I approach, Your Honor?
You may. Thank you. Mr. Medina, would you announce the plea?
Yes, Your Honor. Steve Medina, sorry, I've already said my name 2 or 3 times. Your Honor, under this agreement, it's been signed all parties. There will be a withhold of adjudication in 23 CF 2313, the new felony case. There will be adjudication of guilt in the misdemeanor case, which was a DPA recall, 22 MM 3402. There will be 24 months probation in 23 CF 2313, 615 court costs in 23 CF 2313, 270 court costs in 22 MM 3402, substance abuse evaluation within 30 days with any recommended treatment to commence within 60 days. And that applies to the 24 months probation in 23 CF 2313. She will not be coming out to probation in the misdemeanor case. Random urinalysis, 24 hours community service, no drugs not prescribed, no firearms during supervision, $200 in public defender fees, and the state agrees not to charge on the FTA. And by doing this global agreement, it resolves her misdemeanor case. She's anticipating that she's going to be released from jail today. She's making the decision that this is in her best interest. I have advised her that if she fought the felony case, I might be able to get a better outcome than what we're able to get today. But a comprehensive resolution that will deal with her misdemeanor case she thinks is important to getting out. Thank you.
State.
That's the state's agreement, Your Honor.
Okay, Ms. Dills, would you raise your right hand, ma'am? Do you
Yes,
swear
sir.
or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, I do.
So, Ms. Dills, you heard your attorney state the terms of your plea agreement, and those terms are contained in the written plea agreement that appears that you've signed, correct?
Sir.
And have you read this closely and gone over it in detail with your attorney?
Yes, sir, I have.
Had all your legal questions answered about it?
Absolutely.
Because obviously, not obviously, but importantly, you're waiving some valuable legal rights by entering into this. The right to go to a trial, the right to force the state to prove their case. You're giving up those rights so you can get a final resolution here today.
Correct, sir, and I appreciate the mercy of the state and the mercy of the court. I apologize for the trouble, and I appreciate it.
Okay. So you understand and believe this is in your best interest to enter into this plea?
I do.
Okay. Very good. Based upon that testimony, the court will accept your plea on 23 CF 2313. That's the new law, possession of a controlled substance. There'll be a withhold of adjudication. On the misdemeanor 3402, there will be an adjudication of guilt. On 23 CF 2313, court sentencing you to 24 months of probation. And as a part of that, there'll be substance abuse evaluation within 30 days, any recommended treatment to be commenced in 60 days, random UA 24 hours, community service, no firearms, etc., and of course all the fees and costs. So on the misdemeanor,
It really effectively
on the
is.
misdemeanor, I don't see how you're disposing of it.
It's an adjudication of guilt for court costs, Your Honor. She has been in jail. We didn't say time served, but it's effectively part of it.
Okay.
Correct, Judge.
So it's credit for time served in the misdemeanor.
That's fine. We can say it
Okay.
that way. Thank you.
Okay, very good.
I would ask that the monetary obligations from the misdemeanor case transfer to the felony case.
Right, and then it'll be done during the probation, so during the 24 months.
Do I need to write that, or Madam Clerk, are we okay with that?
I'm writing it on minutes.
Yeah, good, thank you.
That's fine.
Thank you.
Okay, any questions, ma'am?
No, sir, I appreciate it, Your Honor.
And the score sheet you're okay with?
Yes, Your Honor, thank you.
Very good. Good luck, ma'am.
Thank you.
Good luck, ma'am.
Thank
Thank
you.
you. Thank you, ma'am. Thank you.
Judge, if y'all want to bring Ms. Green back out, I have her agreement drafted.
Okay.
Yeah, Mr. Gunn, please, if you'll. Oh, we need, who do you need?
Ashley Green.
We need the, AJ, that's.
Thank you so much.
Break.
Oh, you need a break?
At break, and then we do Mr. Bump, language line.
Oh, he's the language. No, hablen. Los.
No. Portuguese.
Oh, I'm sorry, he's gonna be the last one because of language line. Okay.
Wait, the last one.
Ms. Green, they need you back out there. Stay here, thanks.
The last one? No.
After the break.
First, after break.
Counsel for the state, would you just announce the case? This is case number 23 CF 2323.
That's correct, Judge. This is State of Florida versus Ashley Green. She's charged with criminal mischief. We brought her back out because I've drafted the plea and sentencing agreement. When drafting it, I did learn that the damages in this case are less than $1,000, less than initially anticipated, so the state's going to be offering a lesser included misdemeanor.
Okay.
So what that means, ma'am, is instead of a felony, you're not pleading to a felony, you're charged with a felony, you'll plead to a misdemeanor of criminal mischief. You're going to serve 1 year of probation, so 11 months and 29 days.
Okay.
You're still going to have to complete the anger management. You'll still have to do 24 hours of community service, and you're going to have to repay the same amount to the victim, the $406.
I'm at peace with this.
Okay, great.
I have peace of mind.
All right.
That's
so-
better that it's a misdemeanor, because that scared me, because I've never been in that much trouble, and I don't go that far.
Okay, so I've signed here. If you're in agreement with this, you can go ahead and sign, and you'll sign a date.
Do I get released today? Am I here? I'm here.
Right. Her question is if she'll be released today. My understanding is that there's nothing else holding her.
This will resolve this case, ma'am, and I like I say, I'm not
Okay.
aware of anything else.
Do we have another court date after this, or no?
No.
Okay, so this is it, completely.
Look, I'm going to ask you a few questions, and we'll have a little interchange here before we actually. So actually, what the state attorney said, you may not fully appreciate it, but it's actually very significant that you're not being adjudicated as a felon.
Right.
Felon is a much more serious crime.
I know.
Much worse on your record.
It's not something, and I don't ever go that far, and my anger is never that, I wasn't angry, so I'm
Hopefully,
lost.
but anyway, but the state appropriately lowered this because of the the values earned, so they followed the rules, and it resulted in something positive. That's okay. So you're pleading guilty to the lesser included charge of a misdemeanor, criminal mischief, and you're going to be on probation for 11 months, 29 days. And during that time, you got to do anger management, 24 hours of community service hours, and then repay the victim the restitution in the amount of $406.59.
Yes, sir.
So is that your understanding of what the agreement is?
Yes, sir. I understand.
You understand, if you read this agreement closely, you have signed it, but you don't know how closely you read it, but you're giving up some legal rights by entering into this. I just have to tell you that you could contest this, say, you got to prove this case. You're waiving the right to go to a trial in order to get this resolved.
I
You
just
believe
want-
this is in your best interest?
That is in my best interest, just to resolve it now, because I can't keep doing this.
Okay,
It's good, I don't need my head messed with.
okay.
I don't,
Well, the most important thing,
my mental health is really not all that great, so I've been getting help at Bridgeway Assistant Living where I can, so I don't like psychologically being messed with. And this would just,
sometimes there are periods.
it would stop right here. That's just what I want. I don't need it going further. I don't need my mental health getting any worse, my emotional health, or any of it.
Judge, you said $460. I meant
That's
to-
406.
Right.
If I said 60, I'm
Thank you.
So, the most important thing that I would suggest to you, I'm sentencing you to the 11 months, 29 days of probation. When you get out, if you either get out to probation today or first thing in the morning. That's the most important thing, is to develop a relationship with your probation officer. What I mean by that is stay in good contact. They don't make them run you down.
I ain't gonna do
You
that.
follow up with them, hey, I'm just checking in, if you got an issue, talk to them. They want you to be successful too.
I
They're not
understand.
trying, but,
I've never, but yeah, this is my first time on probation, so I'm gonna learn myself too.
okay, so, that's my point. What I'm saying to you, listen to what I'm saying. Stay in good contact with your probation officer, okay?
Yes, sir.
That'll get you a long way.
This will be a first for me.
Okay.
I'll be honest.
Good luck, and you do have 30 days to appeal this if you wish to, I have to tell you
Okay.
that. But do you have any questions?
Do I get the paperwork when I go to, when I get released? Do I get paperwork where the probation office is and stuff like that, and who my officer will be? So then I'm not lost where to go, and,
Okay. The probation officer's sitting right over there, he's gonna give it to you before you get out,
all right.
okay? Very good. Thank you, ma'am.
Thank you.
He's gonna hand you some paperwork for you, if you get all that information.
This is going to be Mr. Knapp. Report. Should be number 38 on the afternoon docket.
Okay.
If I can have a moment to let Mr. Knapp sign his plea agreement.
Are you sitting in for Ms. Sandler? Are you sitting in for Ms. Sandler?
Yes, sir, I'm on both of the 230 docket.
The plea? Oh,
Yes.
which one are you doing? Is that the new
Troy
one with
Vincent.
Mr.,
The one with Mr. Owens and
okay. So Mr. Niddle has one too.
Yes, sir, but that's just an agreed upon.
That's just a plea, that's
Yes.
right. That's why I was trying to get that out of the way, that should be short. Are you on that one as well?
Yes, sir.
Okay, so I thought so, but I didn't see Ms. Sandler.
Just for future reference.
Do you have a score sheet?
May I approach, Your Honor?
You may.
No objection to this court sheet.
Thank you.
This is not an applicable.
Okay. Would you please announce the terms of the agreement?
Yes, Your Honor. Mr. Knapp will be entering a plea of no contest as charged in 23 CF 2285. There's going to be a withhold of adjudication based on 36 months of probation, waive the cost of supervision, $967 in court cost, $150 defender fee, required to complete the batterer's intervention program, no violent contact with Ms. Whitney McDonough, and he is entering the plea without the opportunity to review discovery, Your Honor. And for probation's purposes, he does have something that's holding him in, so he won't be released immediately.
Okay, is there a start date, at least, for the batter's intervention programs? You've got 36 months of probation. I don't want to wait 2 years before we start.
If we could say within the first 6 months, Your Honor, he's got
That'd be
the other
fine.
case that he's got to resolve. We want to give him plenty of time.
That's fine. Just put that on here.
Yes, Your Honor.
Sir, is the state in agreement with that?
That's correct, Judge.
Sir, would you raise your right hand? Just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
So you heard your attorney state the terms of the plea agreement?
Yes, Your Honor.
That was on the written plea agreement that your attorney is just making a little notation on, which you have signed. Have
Yes.
you read that plea agreement closely, and have you had the opportunity to ask any questions about the plea agreement with your attorney?
Yes, I
Do you have any further questions regarding the plea agreement?
Not the plea agreement, no.
Anything else?
Right, I was on misdemeanor probation when I was picked up on this felony battery.
Right.
I was just arrested for it technically today.
Okay,
I don't know.
Your deal, okay, stop.
So I don't understand what's happening there.
That's another case.
I understand, but.
Another court,
Okay.
another judge. Unfortunately, I don't have any authority in that case.
Okay.
I'm not trying to cut you off, but I don't have a dog in that one, in that
I
fight.
understand,
I'm
but
not sure.
I don't know how I'm gonna report to this probation
and that's
if
what
I'm
I
still
was-
in jail.
Well, until you obviously, you're not, well, go ahead.
That's what I explained to probation, is that you won't be released this afternoon, so
Okay.
they won't expect you to be there until you're released on this. It's 24 hours of your release, you have to check into probation.
Okay, understood. Thank you.
And
That's important to understand that, because it is important to check right in, but
Yes, sir.
you can't check in when you're in jail.
No.
I understand that.
Okay, thank you.
And as far as the other case, Your Honor, and it's one of those where, as I explained to Mr. Knapp, when he was arrested on this new case, the presiding judge did the order commanding arrest. As it happens, sometimes they fall through the crack, they don't get processed. It was a conversation we had yesterday that I basically was able to get it taken care of, served on him. He should have first appearance in the morning. I do believe with both the judge and the attorney handling the case, he may be able to get that resolved tomorrow as well at first appearance. So that's the hope at this point.
Okay.
May I approach that?
You may. So, do you have any further questions regarding this plea and sentencing agreement?
No, Your Honor.
Okay, and you believe this is in your best interest to enter into this?
I do.
And you understand that this will be a final resolution of this matter?
I do.
Okay. Based upon that testimony, the court will accept your plea. There'll be a withhold of adjudication on the felony battery count. You'll receive or sentenced to 36 months probation. Court will waive the cost of supervision. There's standard court costs, public defenders' fees, etc. In addition, you must complete the batter's intervention program, and you must start it within 6 months of today. And there'll be no violent contact with Ms. Whitney McDonough and the defendant. You do acknowledge that you're entering this plea here today without the ability to go through discovery, normally what would take place. But you believe you understand enough of what's going on and what the evidence would show. Okay. Very good. Any questions?
No, Your Honor.
Thank you very much.
Thank you.
Thank you, Your Honor.
Your Honor, Stephen Dean with Carly R. Alderman Ford. Ms. Alderman Ford is number one on the afternoon, the 1:30 docket. She's before the court in 23 CF 2176. That's a plea day. We will enter a plea of not guilty in that case. The other two cases are 22 CF 2927 and 22 CF 2665. I would ask to continue them all to pretrial on December 13th.
Very good. The court will enter a not guilty plea in the new charge and continue this till 12, 13, and 9 a.m.
Thank you.
Thank you. Sarah Boney. I'm sorry, Benny. I'm sorry, Sarah.
Your Honor, Ms. Sarah Benning is Boenning, docket number 7 on the 1:30 docket.
Okay.
23 CF 2244. I would advise the court that I can't really do anything this afternoon because we have a pending evaluation dealing with competency and NGI issues, and until we get that outcome, there's nothing we can really do it other than get a new court date. If we could continue on December 13th, that makes, we probably need that much time to get the evaluation.
Okay. So I was going to offer to do it in November, but if you don't think that you're going to get the report back by then, it doesn't make any sense to do it. I don't want to just waste any time.
It is dealing with both issues, Your Honor, so that makes it a little more elaborate. And it was, the paperwork didn't go out until October 24th, so I think probably we're going to need more than a couple of weeks.
Okay, so we'll continue this till 12, 13, and 9 a.m.
Thank you.
You're welcome.
Leanna Davenport. Davenport.
Your Honor, could we approach, Ms. Sharpless, could we approach with Ms. Davenport? Is that okay, Your Honor?
Sure.
Could she come?
Yeah. Yes.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
The Cottage Formalware, located at 648 North Wilson Street, has all your needs for looking your best. We have homecoming, prom, and pageant dresses. We have tux rental suits, vests, ties. Need something casual? We have that too. Shop Hometown First and visit us on Facebook at the Cottage Boutique and Formalware. We're located at 648 North Wilson Street. Call 850-682-2446.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Cyclone Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs.
I was letting you know.
If there are any developments in this case that need to be brought to the court's attention, the court will find time to address it. Okay?
Your Honor,
Even if we're outside of a normal docket day, or we'll try and work around it. Okay?
And
I'm doing that as accommodation for your client, Mr. Medina. You can explain to her what that means later.
Yes, Your Honor. She'll enter a plea of not guilty today and be on the December 13 docket. Thank you.
Okay. Thank you.
Should be Barry Brown in it. Barry Brown. Yes, sir. Go ahead, Jim Lectern, sir. Right to the lectern, sir. Right to it. We're just gonna
Your Honor, Steve Medina for Barry with an I, M. Brown. Mr. Brown's case is docket 8, 23 CF 2326. He will enter plea of not guilty and remain on the December 13 docket. Please.
Very good. The court will accept the not guilty plea, place him on the pretrial on 12/13 at 9 a.m.
Thank you, Your Honor.
Thank you.
Ashley Cook.
To the lectern, sir.
Your Honor, Ashley Cook is before the court. Docket 16, 23 CF 1645. We have a misdemeanor time served plea agreement, Your Honor.
You can keep that. It's the same agreement that we went over.
He's signing the agreement that we previously went over, Your Honor.
Thank you.
May I approach, Your Honor?
You may. Thank you.
Your Honor, under the terms of this agreement, Mr. Cook is going to change his plea of not guilty to nolo contendere, and there will be adjudication of guilt to a lesser included offense misdemeanor, driving while licensed suspended or revoked, third or subsequent. It's a first-degree misdemeanor, and the statute reference is given in the agreement. It's for time served, $270 court costs, $150 PD fees. The state agrees not to file on the FTA. Unpaid monetary obligations to collection 6 months after release.
State.
That is the state's agreement, Your Honor.
Mr. Cook, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement, and I see those terms are contained in your written plea agreement that you've signed. Have you read this closely?
Yes, sir.
You go over it in detail with your attorney, make sure you understand all the legal ins and outs?
Yes, sir.
Particularly, you're waiving the valuable rights of going to trial and forcing the state to prove their case, all that stuff.
Yes, sir.
You believe that's in your best interest to do that?
Yes, sir.
And you've had all your legal questions answered?
Yes, sir.
Okay. Based upon that, the court will accept your plea. There'll be an adjudication of guilt to the lesser included offense of misdemeanor, driving on a suspended third or subsequent. You will get credit for time served. That'll be your sentence. You will not have any further supervision, no more probation, no more incarceration. You've got fees and costs, and the state agrees to file, not to file on any failures to appear, and any unpaid monetary obligations that you have on the fees and costs, basically, will go to collections. You'll have 6 months to pay, and then it'll go to collections. Okay, question?
No, sir.
Okay.
Right this way, sir. I gotta get fingerprints.
Good luck.
The wrong Deathridge would be
What we do now?
Yes, Your Honor. Steve Medina with Narong D. Deathridge, and his case is 19, docket number 1923 CF 2154.
I've got a different case number.
We're just denying the VOP today.
I have a different case number. Would you give the case number again?
Your Honor, I'm sorry, 23 CF 2154 is a new law, and we're just going to enter a plea of not guilty.
Okay, very good. That's the one.
There is a VOP case a week from today that he's coming back on. That's 22 CF 959. So it may be we work things out a week from today, but we're not working them out today.
Okay, very good. So we'll enter a not guilty, come back on 12/13.
What day did you say that was?
It's a week from today, sir, at 9 a.m.
Okay.
Thank you.
Leonard Dent.
Your Honor, Steve Medina with Leonard D. Dent, docket 21, 23 CF 2208 and 23 CF 2329. Mr. Dent will enter a plea of not guilty in both cases, Your Honor.
Very good. The court will enter a not guilty plea. We'll come back on 12/13/9.
Thank you, Your Honor.
Caleb Easterling. Thank you, Spencer.
Go ahead.
Steve Medina with Caleb Kent Easterling, docket 24, 23 CF 2318. At this time, Mr. Easterling will enter a plea of not guilty, and he will remain on the December 13 docket, if that's okay.
Very good. The court will accept the plea of not guilty and come back 12/13 at 9 a.m.
And Mr. Easterling is interested in a probation offer. My understanding is that we're going to be getting the state's discovery offer and score sheet, and I don't have it yet. So I believe there is some information.
There was an information.
Has the information been?
I handed him what? How does it look like? It's just a
I don't have, yes, I provided that because.
But yeah, no information.
Okay.
I'm looking,
Is there,
sorry.
yeah.
There should be.
I'm just interested in squashing this as soon as possible.
You don't have that information.
So give me just a second, Judge.
And I have not seen it. We have had some issues with the portal, that's why I may have had some issues.
Okay. We'll blame it on the portal.
On 2 cases for this afternoon, you still don't have it. It's not in.
Well, Your Honor, I do see one in my system. I honestly cannot tell the court. If I do see that it was uploaded in our system, I cannot tell the court if it was e-file. I am clicking e-file right this minute, so there is an
We'll just make sure it
information
was
been.
e-file.
Okay.
Yes, ma'am.
All right, I'll get some information off of here.
The state has generated an information and it will be coming to benchmark.
I'm sure that Mr. Easterling would be happy to come back in a week if we, in abundance of caution, want to not enter the plea, given that there's not an information showing. Is there a plea day a week from today? I'm sorry, Judge, I thought there was.
I think it's a miscellaneous date in the morning.
Trying to get on a full docket, which we have no space for.
Yeah, yes, Your Honor. Okay, thank you, Your Honor.
Okay, thank you.
Mr. Henson Brown.
I was going to go there, and now Miss Davis walks out on me. Would you get Brooke? I was going to do her case out of it. You've been waiting all this time over the case, Mr. Niddle. Sorry,
That's all right, Judge.
you have too many cases, not enough time.
That's the kind of day it's been all the way around. I was stuck in traffic on I-10 this morning for about 45 minutes.
It's not as bad as I-10 out in Los Angeles.
No, you're right about that. It wasn't on fire. That person, I won't hear.
just wait for your counterpart.
Just show Mr. Brown what one of the points he's scoring.
I finally go out of turn to get you guys out on your cases done.
You just can't do anything
You're
nice
gone.
for me, Judge.
If you violate your probation.
And Madam Clerk's not gonna be super excited with me either, because the score sheet, when it printed front and back of the same paper.
Reprint it and I'll go get it.
Okay, thank you.
That's all.
So, Mr. Niddle, do you have your own copy of this plea agreement? I'm going to ask you to announce it.
I know what it says, Judge.
Okay.
Mr. Brown.
Are you in agreement, first of all, on this two-sided score sheet that
Yes,
state has
they
provided?
revised it to the correct numbers today. They had the wrong
Very good.
charges earlier, but there was two informations filed, but the second one's the information, the score sheet's correct now. It wasn't
Okay,
earlier.
good. Okay. Would you please announce the terms of the plea agreement, and I'll follow along.
Mr. Henson Brown would be pleading to shooting into an occupied vehicle and 2 counts of aggravated or attempted aggravated battery with a firearm. He would be pleading no contest to those charges. He would be sentenced as a youthful offender. He would serve 30 months in the Department of Corrections, the youthful offenders camp, followed by 6 months community control, followed by 30 months, I think it's 36 months probation. And there's some fines and costs and community service as well.
Very good. And is the state in agreement? Is that their agreement?
Yes, Judge.
Mr. Henson Brown, would you please raise your right hand, sir? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So, just need to ask you a few questions. 2 things I'm trying to get at. 1, make sure you understand what you're agreeing to. And secondly, are you doing it freely and voluntarily? Okay,
Yes,
that's
sir.
why I'm asking you these questions. So, you heard your attorney state the terms of the plea agreement. Okay? And I see that those same terms are contained in the written plea agreement that you've signed. So my first question is, did you read this closely?
Yes, sir.
And did you go over it in detail with your attorney? Make sure you had all your legal questions answered about, because there's all kind of legal stuff in here. Have you had a chance to go over and ask any legal questions?
No, I don't have any legal questions.
You don't have any legal questions, okay? And you understand, importantly, by entering into this plea agreement here today, you're waiving some valuable legal rights.
Yes,
The right
sir.
to go to a trial, the right to force the state to prove their case beyond reasonable doubt, and all that stuff, confront witnesses, but you're waiving all those rights in order to get a final resolution.
Yes, sir.
You believe that this is in your best interest to do this?
Yes, sir.
Okay, and is there a factual basis
We'll
for the entry
stipulate,
of this plea agreement?
we'll stipulate to the factual basis contained in the probable cause affidavit, Judge.
And you do believe this is in your best interest to enter into this here today?
Yes, sir.
Very good. Based upon that testimony, the court will accept your plea. The defendant will be sentenced as a youthful offender, and the court is sentencing you to 30 months Department of Corrections, followed by 6 months community control, followed by 3 years standard probation. As a condition of the probation, you do have to have 50 hours of community service. And just for the record, what are the standard fines and costs? They were not included, the exact amounts? We'll put it.
I have a 515 cost with a 201 trust fund and a 151 assault fee.
Okay.
For a total of 867. If
And-
you want the FDL,
Yes, it should be 967.
you want FDL in there?
Yes.
Okay, that's optional.
Okay. So 967 and
And also the court appointment cost for Mr.
very good. And Mr. Henson Brown, you will have you will be able to pay those during the terms of your probation. Okay?
Yes, sir.
Any questions regarding any of this?
No, sir.
For the court, for the record, sir, he has 565 days credit for time served.
Okay. I can't make that call. If that's what you're telling me. I mean, I'm not disagreeing with you, but I'm not agreeing. I don't have any idea. It's not my call to make it. Whatever the days are, they are.
It's a fact-based statement.
It's a statement, and you're welcome to make it. But I just didn't want you to think by me nodding my head yes that I was in agreement with, because I don't know it. I don't know what the amount.
I understand. Sometimes judges like to hear what the credit for time served is. Also, Judge, I believe one of the questions in a plea colloquy such as this, there was DNA swabs taken. None of those were exculpatory or inculpatory towards Mr. Henson Brown.
Okay. Thank you for adding that. And Mr. Brown, you do have 30 days, even though you've agreed to this and you're just being sentenced, you do have 30 days to appeal this sentence. Okay?
Yes, sir.
Anything else, Mr. Niddle?
No, sir.
Thank you for your assistance.
Good luck to you. That's all I had, Your Honor.
Thank you.
We're gonna take I think we're gonna take a recess.
We can take a break?
Take a break. Should be
Is that the last one we have? Because I've got several here that I've got.
Not inmates, Your Honor, so maybe they're out of custody.
Well, let me call these out of.
Your Honor, we've got one more person who was out of custody that I wrote up a plea agreement for, Mr. Alonso.
Is it Alonso? I've got several others, but let's do Alonso first.
And Your Honor, that was 23 CF 2279, Judge. I did prepare a handwritten plea agreement for Mr. Alonso for adjudication, a plea to a lesser included misdemeanor, DWLSR, third or subsequent offense, the credit for time served, Your Honor, and the court cost. And I gave that agreement to Mr. Alonso and told him that the court would inquire whether this is something that he wishes to take. He stated that earlier, but now that he's had time to think about it, the court might want to inquire whether he still wants to.
So, Mr. Alonso, you're still under oath. I think I swore you in before, didn't I? So, you've read the plea agreement. Do you feel like you understand it sufficiently, and do you wish to accept this plea agreement here today?
Yes, sir.
You believe it's in your best interest? Have you read through the whole plea agreement?
Yes, sir.
You understand that by entering into this plea agreement here today, you're waiving the right to go to a trial and to contest all this. Court would, appoint you a public defender. You can fight this. You believe it's in your best interest to waive that and have a final resolution by entering into this plea agreement here today?
Yes, sir.
Your Honor, I'm approaching the podium and I'm going to sign the plea agreement. I don't worry about that. Do you need a pen? And Your Honor, before I sign this does require 10 days in jail. The state stipulates that he has served those 10 days in jail.
Okay.
I'm going to write that in the plea agreement. All right, you don't sign that. I just added that you're going to get credit for those 10 days and all the other days. Since you agreed to.
Right here, right?
And Your Honor, if I can approach the bench with the plea agreement.
You may.
This is a misdemeanor, it does not require this portion.
Okay. Very good. Okay. So, Mr. Alonso, you've read through this and you feel like this is in your best interest to enter into this plea here today?
Yes, sir.
Any other questions that you have?
No, sir.
Very good. Based upon that, the court will accept your plea here today. There'll be an adjudication of guilt to the lesser included charge of driving on a suspended third or subsequent. That's a misdemeanor. You'll get credit for all time served. That's essentially your sentence. And you're not going to be placed on probation. You're not going to have to serve any further incarcerative sentence. The state stipulates that the 10 days in the Okaloosa County Jail has been served. Okay? Any
And
questions?
Your Honor, the statutory reference to the misdemeanor is in the plea agreement for Madam.
Correct. Any questions, sir?
No, sir.
Thank you very much. Good
Mr.
luck.
Alfonso, I gotta get your prints over here real quick, okay?
Okay, so let me go through a couple names here that I've got. Where's Mr. Medina? I've got several out of custodies for Medina.
Step out when you go.
Let me see, are you done with all yours, Mr. Gates?
No, Your Honor.
You want to do those now, or you want to do it after a
We've
break?
got one language line, and the other one is Clayton Glover, which would release Mr. Lasco. I'm pretty sure if we can handle that.
You want to do that now, or you want to take a break?
We can do that now, Your Honor.
Glover? Let's do Glover.
Can I get the case number on that?
23 CF 222.
That's what I was waiting at. Mr. Alonso. Sorry, the way it was written on here.
1 year.
Fine. 1 year?
1 year.
Okay, 1 year pay.
Judge, I would request a capias. I don't see the defendant in the room.
Which one is it? Which
Clayton Glover, you're on the morning docket, Your Honor.
On the morning docket?
Yes, Your Honor.
We're doing the morning docket?
It's the last one for Mr. Lasco. Maybe you can be released.
You were holding out, hoping he'd show up, right?
I tried, Your Honor.
Glover, Clayton Glover.
Yes, Your Honor. And it looks like a notice to appear was sent.
Court will issue a no bond to capias. Failure to appear. Okay, very good. Do you have
Thank you.
any from this afternoon? No.
Mr. Goncalves, but that is the language line.
That's the language line. We're gonna try and figure out how to do that.
Judge, may I be excused?
You may.
Thank you.
Mr. Medina, I've got a couple that are out of custody that I've got on yours this afternoon.
Yes, Your Honor.
Kevin Allen.
Pretty sure we did a not guilty plea for Mr. Allen, Your Honor. Please let me verify.
A written.
I have it as not guilty.
We did a written plea of not guilty for
Okay.
Mr. Allen. It was probably yesterday, Your Honor.
That's all right. Just want to make
For
sure,
sure.
make note of it because it's on our docket. So written not guilty.
Yes, Your Honor.
What about Artie Gene Anderson?
He was here. I told him that he did not need to stay because we did a written plea of not guilty for him as well yesterday, Your Honor.
Okay, written not guilty. Very good. And let me see. Larian Shonay Brown.
Yes, that is a case where Ms. Basso indicated no pros was entered.
That's correct, Your Honor. Ms. Basso did leave notes with us and
Very good.
indicated there was no.
Court will note that was null pros by the state. What about Ashia Campbell? Mr. Medina, that's one of yours?
Yes, Your Honor. Ms. Campbell, we did speak with yesterday, and we did a written plea of not guilty.
Okay, written not guilty. Very good.
We definitely did a written plea of not guilty, but I think I spoke to her today, not yesterday.
We won't hold you.
Yeah. Just didn't want to make a mistake on that, on the record.
Okay, and then there's another Campbell, Shauna K. Judy Ann Campbell.
Yes, Your Honor, we did a written plea not guilty for her as well, and so I think we're basically on December 11th for her.
Okay, very good. Very good. Luis De Leon, Mr. Medina's.
My understanding is that that individual has a private lawyer as of, not sure what day, but,
We put Ms. Gooden on the case today.
thank you.
Cheryl Gooden.
Was he noticed to be here?
Your Honor, Miss, it looks like a written plea of not guilty was entered yesterday.
Okay.
And then Ms. Gooden was assigned as well. It looks like Mr. Medina and Ms. Gooden filed on the case.
Okay, so we'll come back on 12/11, and there's a written not guilty plea entered. Okay? And Goncalves, is that the Portuguese? What about, we had an Elizabeth Dills? Didn't we have that from the?
Yes, Your Honor, I believe she did a plea about 30 minutes ago.
She was one of the units.
Right. I thought so.
Yeah.
Okay, that's all I've got. Let's take a break. We'll come back. I've got to try and figure out, we're going to go with our afternoon docket. Mr. O'Reilly, you've been very patient.
Judge, and I am going to be asking for a continuance. I don't know if you want to address it now or later.
We have him up here if you want to do it real quick. It's going to be a continuance.
We waited all this time to do a continuance? We could have done that anytime. Let's bring him up. I mean, have you filed a motion? You're going to have to give me a good reason. We're ready to go. I just don't have enough time on my docket just to move them around arbitrarily.
I'm sorry?
I just don't have enough docket space just to move them around if you've got a basis. Did you file something?
I filed a motion to dismiss.
I understand that, but did you file a motion to continue it?
I have not. Judge, are you Shay Jones? This is Shay Jones before the court. Judge, I had filed a motion to dismiss counts 2 and 3 back in August. When I got here, I mentioned to the prosecutor over the bench, I said, are y'all going to contest it? She said to me, we filed a response. And I said, I never got the response. I know I filed a notice of appearance as co-counsel, and I don't know whether the clerk can verify whether or not the notice was sent out, but I checked with Jeff.
If you're on there and something is filed, it automatically gets pushed out to the emails. That's my understanding.
We have Mr. Tony on the case. So
Is there a reason? Are you co-counseling with Mr. Tony?
I am.
to attorneys, Your Honor. We just don't have that capability.
Judge, the notice of appearance from Mr. Owens clearly says that Jeff Tony is the attorney, is lead counsel on the case. I can show in our system that it was our response to their motion to dismiss was e-serviced to Mr. Tony on September 6th at 11:28 a.m.
Well, no question. I mean, I'm sure that's the case.
Judge, generally how, and I do some e-filing on my own. I have my staff do some e-filing, but when it comes down, when you're e-filing it, when it comes time to send notice, there's usually a list, the clerk, state attorneys, and you can either punch them individually or you can punch at the top, which notifies everybody. And, you know, routinely, we punch the top so that everybody gets notice, former public defenders, former RCC1s, former prosecutors, so there's no question that everybody got notice. I thought that when I filed my notice of appearance as co-counsel that I would automatically be put on that list. But I had my staff check. I didn't know that there was a response. I'm the one that filed the motion to dismiss. I'm the one that was pursuing this action. I am entitled to notice, I would think.
Well, technically, I think you got notice when your co-counsel got it, technically. But I understand I mean, I don't know. So let me ask you this. What's the solution for this not to happen again? Are you saying you're looking over the clerk, and I'm not blaming the clerk. I'm not saying I'm trying to be solution oriented. If there's something that you need to be doing, like checking with the co-counsel or whatever, I will tell you, there's a number of people that co-counsel. No, it's not everybody. I mean, there's a percentage that's just relatively small. But in numbers, there's a lot of people that co-counsel. I've never had this come up before. I'm just telling you.
And I don't do a lot of co-counsel cases. I've probably got 2 or 3 pending where I'm assisting other lawyers. So I've never had this happen before.
What I'm trying to do is say, I don't know what the problem is. I mean, I understand the way you explained it, but I still don't.
The state is saying that you sent notice in September to Jeff Toney, who is lead counsel. I know that I filed a notice of co-counsel. I assumed that once I did that I would be on the list, so that just like state attorneys, where they have 2 or 3 state attorneys listed, I would be on that list to be sent. But
I'm hearing.
You're thinking that the clerk receives responses from the state and then sends them out to everybody?
No, when I filed my notice of appearance as co-counsel of record, that I would be put on the list.
I'm talking about the response that the state filed, and it was filed on September 6th, which is there in the case.
Right.
Did you see that?
No.
It's been in the case. We don't notify them of something like that.
Do you have?
When the state would respond, it's up to them to look at the files, what you're saying.
Yes, sir.
They're saying they don't even send out.
No, it was sent out. I mean, we could show.
But you sent it out.
Judge, yes, it was.
No, the clerk, this is not a clerk issue.
No.
You sent it out.
We sent it out as part of e-service. It goes to whoever is listed in the file by the clerk's office. So notice requires going to the lead counsel, which is who the clerk's office had listed, and that's where it went, was to Mr. Toney in September.
You're saying the state attorney's office always sends it to lead counsel, not to all counsel.
That's how it's linked. That's how the e-service is linked up from the clerk's side.
Judge.
We have Mr. Owens on the case, Your Honor.
I know.
But we have Mr. Toney first.
Yeah, I understand.
Judge, when you e-file, there's a list of people to potentially notice. You can click at the top, which notifies everybody, or you can click individually. So I don't know how it was done. I just know I didn't receive either A, my name wasn't clicked, or B, my name wasn't on the email list of people to send notice to. One of the two. Now, your question to me was how to remedy this. I assume that if I drop the ball...
Here's what I'm going to say. I'm going to give you a continuance because I'm not going to force this on you without notice. But you should have gotten notice, and somebody should have noticed either you looking at it or somebody else is. But it's not up to me to figure out who needs to get served. If somebody is not legally served, then I come into play. But you were legally served because it went to your co-counsel. The other informal, hey, here's what we do, we send this around. I don't get into who gets copies and who does. I'm assuming that's going out where it's supposed to go. God help me, I couldn't even begin to follow that stuff. So, but I'm going to give you a continuance because, I mean, I trust, I believe you when you say you didn't receive it and we're unaware of the response.
And I think there's a record that...
Judge, I want to make...
What's that?
The Chief Deputy of Operations is listening in on this and has just advised me that e-service is maintained at the portal. The clerk does not maintain the e-service list.
So the portal is in Tallahassee. The portal you're referring to is in Tallahassee, right?
The e-service is
portal
maintained
is?
at the portal.
I don't know where the portal is. The portal's in...
It's embedded in our
It's in the cloud. I don't know where.
I know whenever we e-file something, it's Eastern Standard Time, so I assume that it's in Tallahassee because that's the timestamp.
Except for 3 places. Folks over here.
Judge, I just want to make clear, I mean, I don't think that it would really change here today. I mean, if Mr. Owens was arguing about...
Here's what I'm going to do, Mr. Owens. I've read her complaint. I'm going to go out on a limb and say this. They've cited case law on point at the first DCA that overrides your point to your point. And I would ask you to look at their case law, and if you feel like you can make a good faith argument, we'll reschedule it, but I would just ask you to please do that.
I will, Judge, otherwise
It looks like on point first DCA cases.
And otherwise, if I'm convinced of that, I'll abandon the motion. But I need a chance to look at it and read the case law.
Okay. So you're gonna have to call my judicial assistant in order to get a hearing.
Now, Mr. Jones, Judge, has been taken into custody by the U.S. Marshals. Is that correct? And you're facing a felony charge of possession of a firearm by convicted felon? And where is that court? Is that in Pensacola? Where are you being housed? Judge, I don't know which case takes precedent. This one started before the federal case.
I don't know. Have you ever heard of any state case ever taking precedence over a state case?
No.
If you found one of those, let me know, because that'd be a first.
He's currently being housed in Santa Rosa County. A writ of habeas corpus had to be done in order for him to be brought over here. We had to do a bodily attachment to bring him here for court today. So I would ask that if Mr. Owens would like to reschedule this hearing, that it would be on the onus of the defense to prepare those motions in order for him to be transported over here again.
I
Because
agree.
again, the state is in opposition to the motion to continue today.
I agree. So you'll need to take whatever, maybe you can check with their office about what they had to do to get him over here out of.
I will. And I think what I need to do is probably check with the U.S. Attorney over there about what their position is on this, and
I wish I could, you know, if I had a sense for it, I would share it with you. I don't mind sharing it with you, but I don't. My experience is generally be that the feds do what they want and they inform us after it happens. I'm not trying to be cute about it, but is that state attorney? That's generally the way I experience.
Until the case is sentenced, then the federal case takes precedent.
Judge, can we just set a call date for this, just in case, or should we just leave it outstanding and let me check with the...
No. Well, right now, you all are going to have to call my office in order to reschedule this hearing.
Yes.
Before that happens, I just ask that you spend an hour, read some of those cases, and determine whether or not you believe there's valid defense and arguments to be made. And if you do, then call the state council, you're the state, and the state attorney's office, and go ahead and schedule up. That's the way Miss Eileen does it. She'll get both the assistants on the line. We'll get you a date.
Do you want to schedule a date other than just a control date, or do you want to just leave it outstanding and let me schedule something?
We're continuing this hearing today. And the way we've been doing it is date to be determined.
Okay.
So we're leaving it in the court file. And that's always a little tricky. Not having it. Is he?
This is Shay Jones.
Do we have another case, a pre-trial set for this case?
It's set for the 14th of December already, or the pre-trial conference.
No, the pre-trial conference, the standard pre-trial conference every 2 months is December 13th. But this, an extended hearing like this will not be done on that. That's your massive pre-trial.
I understand. Thank you, Judge.
Thank you.
Judge, I have nothing further for your honor.
Come on, my bad. He's got to check his calendar and get language on it.
Let's do it right. We've got to do, yeah, one of them's one is yours being continued, Mr. Medina? Mr. Boone?
I haven't been able to get in the attorney-client room because court personnel had to be out here. But Boone will probably be a continuance if he doesn't want to do a plea to the bench. But we're not going to have a BOP evidentiary because state's not ready for that and didn't have adequate notice.
Okay. We'll just deal with both of those.
And then Beecham, I think, is going to be fairly brief legal argument because I've already filed a detailed motion in limine. The state's going to do a initial verbal presentation, and then we may follow up with additional briefing depending on any input from the court. So I don't think it's going to take long.
Okay, very good.
Chief, right out there. It's not that female?
We'll take a short break.
All right, court's in a short recess. DDA, we're in a short recess. We're going to do gun plays when we come back with the translator, and then Boone's probably going to be continuing, but Mr. Medina's coming around.
You may have to, could somebody open the door, the courtroom door?
It's open. You had someone open it for you.
All right,
The doors are in it.
Appreciate it, man. Thank you.
Yes, sir.
That's all. That's what I, and y'all been trying to get me to